Okay, good afternoon, everyone. Can I just echo what Barra has said in terms of thanking the organisers of the conference for the invitation to speak here today. I was listening to the news yesterday and heard a little report about David Moyes arriving at Old Trafford yesterday afternoon, where he was to meet with some of the Man United playing staff and coaching staff and some of the fans. And I was just thinking about he has a big job on his hands in terms of managing expectations amongst that group. And I think I've got a similar job here after some of the speakers this morning and after Barra. And in particular, there are a couple of other factors that I think I need to explain to you. One is that I moved house yesterday, and before moving house, I packed away the notes for today's speech in a box that I marked definitely not to be lost. And then, of course, this morning we couldn't find them. They were located, but only about 45 minutes ago, so you'll have to bear with me. And the other thing is that I was appointed, as Dawn said, I sit on the Criminal Cases Review Commission. I was only appointed to the Commission late last year and only started work with the Commission in January. So I'm a relative newcomer to the Commission, and I'm going to talk a little bit about the work that the Commission has done in relation to conflict-related cases in Northern Ireland. But of course that work goes back to the establishment of the Commission. And it's really just, I suppose, by accident of location that I've been asked to undertake this task for the Commission. First of all, just to give you a little bit of background about the Commission itself. The Commission is an independent, non-departmental public body. It's based in Birmingham. But it has responsibility for investigating miscarriages of justice in England, Wales, and in this jurisdiction. In Scotland, they have their own separate Criminal Cases Review Commission. The Commission was established as a result of the Criminal Appeal Act in 1995, but it has, of course, it owes its origins to cases that are linked to the conflict here. Because, of course, as a result of the Birmingham 6 case and the Maguires and Judith Ward, etc., and the Guildford 4, a commission on criminal justice was set up under Lord Runciman, and it was as a result of his recommendations that the Criminal Cases Review Commission was established in 1997. The Commission receives somewhere in the region of 1,000 applications a year, although that has increased dramatically in the last 18 months to 2 years. And no one is really quite sure why that is yet, but I mean, I think it has effectively doubled in the last 18 months to 2 years. It has a budget of about £6 million and a staff, including commissioners, of about 85. Since it was established in 1997, it has dealt with somewhere in the region of 13,000, just above 13,000 applications. It can refer, as I said, its responsibility, its primary responsibility is to investigate alleged miscarriages of justice. So if you think that you have been the victim of a miscarriage of justice, you can apply to the Commission to examine your case. Now, prior to the establishment of the Commission, it used to be the case that if you were in that situation, you had to apply to either the Home Secretary in England and Wales or the Secretary of State here, and anyone who had to use that system either as an applicant or as a lawyer representing them will know how difficult that system was and how generally unsuccessful it was. Very, very few cases were ever referred by that route. The Commission, on the other hand, refers quite a number of cases, and it can refer a conviction to the appropriate Court of Appeal either here or in England and Wales if it considers that there is a real possibility that the conviction, or in some cases the sentence, would not be upheld were the reference to be made. That must be because of an argument or evidence that has not been raised previously, and the applicant must have had an appeal determined or leave to appeal refused. There is one caveat to that, in that the CCRC can make a referral in the absence of those conditions if it considers that there are exceptional circumstances that justify the referral, and it has used this power in some of the Northern Ireland cases. The test applied by the Court of Appeal here, which is broadly similar to the test in England and Wales, is that it will allow an appeal against conviction if it thinks that the conviction is unsafe. Now, unsafety, most of us will notice the difference, but just to point it out, unsafety is a different test than innocence, and it's a broader test than innocence. So it may mean the court will quash the conviction of someone it believes to be factually guilty if the methods that have led to the conviction are flawed. So that's the sort of statutory background to the Commission. In terms of the work in Northern Ireland, it has no specific role in relation to historical investigations and information recovery here. And I mean, there were some comments this morning about how some of the presentations effectively were little discrete piecemeal parts of a system. Well, that's very much the case with the Criminal Cases Review Commission. There's a very limited and specific role that it has. Having said that, it can look at any criminal conviction arising from the courts in Northern Ireland. All of them are within the jurisdiction of the Commission. So anyone can apply, whether they've been convicted as a result of the conflict here, or whether it's what we might term an ordinary conviction. But it is true to say that a large majority of the applications that the Commission has received have arisen out of troubles-related convictions. I was looking at some of the figures in Birmingham last week, and these are figures that the Commission gathers. There have been around about 335 applications to the Commission from Northern Ireland, and around about 250 of those relate to the conflict. And of those 250, 33 have been referred to the Court of Appeal. Now, there's a couple of points I just want to make about those figures. One is that this is a very high rate of referral. It's about 11%, which in comparison to figures in England and Wales, the figure in England and Wales, is around about 3.5%. So it's significantly higher. And it's also interesting because the Northern Ireland prison population at the moment makes up around about 2% of the combined Northern Ireland, England and Wales prison populations. But applications to the CCRC from Northern Ireland at the moment and for the last year or two currently only represent about 1% of our intake. So it does suggest there's an underrepresentation in terms of Northern Ireland cases. And the Commission is doing a little bit of work at the moment to see why that might be the case. But if you were to take out the conflict-related cases, it would be a massive underrepresentation. So that is something I think that the Commission will have to look at. It's also noteworthy that when cases are referred to the Court of Appeal by the Commission in Northern Ireland, to the Northern Ireland Court of Appeal, it's of course for the court to decide whether or not the conviction is unsafe and whether it should be quashed or whether the sentence is incorrect and should be varied. But of the cases referred, convictions have been quashed or sentences amended in 27 cases. In 2 cases, convictions have been upheld, and there are a few where we're still awaiting the court's ruling. So again, this is a very high success rate, round about 90%, compared to a success rate in England and Wales of about 70%. So if you're looking at this from the point of view of an applicant or a solicitor representing an applicant, the most difficult barrier to overcome is persuading the Commission to refer the case. If the case is referred, either in Britain or here, you've got a reasonably good chance of success at the Court of Appeal. So that's some sort of background about the Commission and its work in relation to cases, some general background information. The other thing that I wanted to just touch on was some of the key issues and challenges that the Commission has faced in terms of dealing with conflict-related cases. The Commission has no sort of corporate view on how to deal with these cases. I suppose similarly to maybe what Barra has said, if cases come to the Commission will examine them. And at the moment there is no cut-off historical date, and any criminal conviction can go to the Commission, so it could be a careless driving right up to a murder, and the careless driving could date from 1950 with all of the problems that brings. And clearly dealing with troubles-related convictions does bring lots of practical problems, and the Commission faces them like others have faced them, and we heard some of this morning. Obviously, the longer time that has passed, the less documentation tends to survive, the more memories tend to fade. Of course, in relation to many of the conflict-related convictions, there's the issue about sensitive security information. That means that there are procedures within the Commission for handling all of that. That can be done, but it does add to what is already a slow process. If you're not in custody, and most applications relating to the conflict, certainly historical convictions relating to the conflict here, the individuals won't be in custody. You can expect to wait anywhere from probably sort of 18 to 24 months for the Commission to deal with the case. So it's a long process, and like every other public body, there are resource constraints at the moment. But the types of issues that have come to the Commission's attention in those cases that have been referred have included a wide range of things, some things that you won't be surprised about, issues around the handling of informants, non-disclosure of relevant material, and on those issues the Commission has sometimes overlapped with the work of the Ombudsman and with the HET. And there have been a number of high-profile cases. I'm not going to go into much detail on them, but the vast majority of referrals that the Commission has dealt with relate to concerns around interrogation of suspects. And this was mentioned earlier on in one of the questions from the audience. Looking through the referrals that the Commission has made, I think there are about 25 that relate to concerns about admissions made in the holding centres. Many of those relate to the issue of young people in custody. And there have been a series of Northern Ireland Court of Appeal judgments relating to the situation of young people in custody. And as many of you will be aware, for those arrested under the emergency provisions legislation and held in the holding centres, for many years, if they were under 17, despite the fact that they were under 17, they would be questioned in the absence of solicitors, as all individuals were who were held in the holding centres up until the late 1990s. But they were also questioned in the absence of an independent adult. So in other words, a parent or responsible adult generally wasn't present. Now, the Commission began to refer cases arising out of those sort of factual circumstances and had a general degree of success in terms of the referrals to the Court of Appeal. And the Court of Appeal, in a series of cases, culminating in a case called Fitzpatrick and Shields, which was a very short judgment, essentially quashed most of those convictions. And in Fitzpatrick and Shields basically said, you know, these people were interviewed without lawyers, without independent adults, and as a result of that, were quashing the convictions. Now, that happened in a whole series of cases: Adams, Mulholland, McMenamin. Some differences, but that was the basic thrust of the jurisprudence. Now, these were cases as well where not only were these young people questioned without legal advice or without any other independent adult being present, but of course there were cases where all of the young people had confessed. They had, generally speaking, pleaded guilty. In some cases, refusing to recognise the court, but generally speaking, pleading guilty, and generally speaking, did not appeal. Now, in most cases, the Commission would not consider referring cases such as this, where people had pleaded guilty and refused to appeal or did not appeal. But in a lot of these cases concerning young people, they did refer them, and the Court of Appeal quashed the convictions. But there has been a recent and pretty significant change in that situation. In a case last year involving 4 young people, Brown, McCall, MacDonald and Wright, the court seems to have rolled back significantly from those earlier judgments. And it is basically said in future that it's basically said that failure to follow the procedures, such as having an independent adult there or having a lawyer there, will not necessarily render a conviction unsafe. It will look for other factors. So in each of those 4 cases, it took a different approach. In the case of MacDonald had confessed to an incident that it was subsequently discovered hadn't happened. So the Court of Appeal quashed that conviction because that was an additional factor that made it uneasy. In McCall, the young person was clearly suffering from a significant degree of mental incapacity, and the court again quashed that conviction. But in the other two cases, Brown and Wright, there was nothing beyond the breach of the rules at the time, so the court said, we're not simply going to coerce those convictions on that basis. So they've developed a sort of slightly different approach, if you like, and that has meant that a number of applications that were sitting with the Commission waiting for that judgment, the individuals have now been written to and told that the Commission will not be referring those cases. So that is a difference, a significant difference that the court has adopted. The other thing I wanted to touch on, I mean, there are lots of other issues that come up in some of these cases. I mean, we've had cases that have been referred through the use of ESDA testing where interview notes have apparently been rewritten, and the court has taken a very dim view of that. And even in the absence of anything in particular, in the absence of medical evidence or anything like that, they have coerced the conviction nevertheless. The other matter of grave concern is in relation to police misconduct in some of these interviews. The CCRC has quite wide-ranging powers, so it's been able to access files relating to complaints made against interviewing officers, and it has referred a number of convictions from the 70s and 80s based on new evidence that other suspects, not the applicants to the Commission, but that other suspects interviewed by those same officers had been injured during detention. Now, the Commission will engage in a full analysis of the case. It won't refer simply on that basis, but it has made referrals where such evidence exists. And just to give you a quick example of one of those cases, a case called Mcdermott and Mccartney, the Commission discovered some new evidence which it considered could undermine the credibility of the interviewing officers. And some of this evidence related to a defence witness at the trial, who was a guy called Donnelly, who had originally been charged as a co-defendant of Mr. McCartney and Mcdermott. Mr. Donnelly gave evidence at the trial and said that he had been assaulted while in police custody. There was a discussion between the judge and counsel, prosecuting counsel, about why the charges against Mr. Donnelly had not been proceeded with, but the judge decided to continue the case without an answer. In fact, the charges against Mr. Donnelly had been dropped partly because the then DPP had advised that his treatment in custody and the injuries he had sustained would militate against the court accepting the statement as voluntary. And there was also evidence that two of the interviewing officers who had obtained a confession from Mr. Mcdermott had obtained a confession in another case, in an unrelated investigation, where again the DPP had not proceeded with the prosecution because of the injuries sustained in custody. So that's an example of where the Commission can use, as I said, quite wide-ranging powers to look at the background of some of the investigating officers and see whether there have been other complaints that have been upheld. If there have been, that's a factor that can be taken into account. How am I doing time-wise? Okay. One other thing, well, a couple of other things just briefly to mention. I've only got a minute left. I said at the start, some of the allegations related to mishandling of informants, some of the referrals, and other sensitive matters. In a number of cases, and you may have seen some of this in the press recently, in a number of cases where the Commission has referred cases to the Court of Appeal, it's done so and sent a confidential annex to the court. So the confidential annex will contain sensitive information that the Commission thinks raises a question mark about the conviction. So it may be that the applicant's case is referred to the Court of Appeal and the applicant may not know the reasons why the case has been referred. And there is some ongoing litigation in the courts at the moment about trying to get some of that information out. The other thing I just wanted to say really was in relation with two other very brief matters, if I may, Dawn. One is in relation to the issue of victims. When the Commission works with applicants, our role isn't to treat those applicants as clients. And the applicant may be claiming that he or she is the victim of a miscarriage of justice. So our job is to identify whether or not the court will quash the conviction. We're not deciding whether or not someone has been the victim of a miscarriage of justice. That's what the court decides. And on the other side of the coin, if you like, in cases where there are victims of an offence, the Commission generally does not contact those people if an application is made to us. We'll only do so if in appropriate cases a referral is being made and we think there might be some news coverage of the case, etc. So in a relatively small number of cases have we contacted victims, but that process seems to have worked reasonably well, I think, so far. And then one final point, which is that the Commission does retain a discretion in cases, and this has been exercised in a couple of Northern Ireland cases. And one that I'll just give you as an example is in an application from Michael Stone, who applied to the Commission to have one of his convictions, two of his convictions for murder, referred back to the Court of Appeal. The Commission essentially took the view that even where there might be evidence to justify a referral back to the Court of Appeal, because Michael Stone had subsequently been convicted of a series of other murders, the Commission was using its discretion not to refer back. So in other words, it's a basic sort of public policy point. If you've subsequently been convicted of much more serious or equally serious offences, there's little point in referring your case back to the Court of Appeal. So that's as much as I want to say, but I'm happy to take any questions that you might have afterwards. Thank you.